Okay, I'm going to get out of the way and let Mechele Dickerson. She's the moderator for this panel, and we're so grateful for her taking the time to do this. Very, very thankful that you were willing.
I am delighted to be here. The only reason I teach Remedies is because Terry took Doug away. I was the associate dean at the time, and I had to go and try to get Remedies covered. And so I begged everyone on the faculty, would you please teach Remedies? We really need Remedies. No one would agree to follow in Doug's footsteps. And so Associate Dean Dickerson told Professor Dickerson, guess what you're going to be teaching? So that's why I'm teaching Remedies. Thank you, Terry. Yeah. We're going to do a format of each in order, and we're going to the shortest introductions known to humankind. Professor Sam Bray at Notre Dame, you're in the wrong order, but Professor Rick Hasen at UCLA, and Professor Emily Sherwin at Cornell. We're going to do roughly 10 to 12 minutes each. The panelists can sort of ask questions in between. You cannot. We'll then save time at the end when you all can then ask questions with that. Sam.
So I'm going to do no trash talk for law and religion. Taking a cue from Larry, I'm going to show equal regard for the two fields. Zechariah Shafee once said of one field in American law that it had suffered the fate of the Austro-Hungarian Empire, that it had been pulled apart, parceled up, and gone away. Most scholars will work in a field that's in a steady state. A few will work in a field that is deconstructing, but very few, almost zero, will be generative of a field. And Doug has been generative of the field of remedies. He has written the leading book in the field of remedies. That's The Death of the Irreparable Injury Rule. It has a particularly special place for me as a formative thing for me. When I was a new professor at UCLA, the first seminar I taught was non-monetary remedies. The central text for that seminar was Doug's book. That is the reason. I don't know if this is still true, Rick, but as of that time, that's the reason the law library at UCLA had 12 or 13 copies of The Death of the Irreparable Injury Rule. He is the author, now with Rick, of far and away the leading case book in the field of remedies, and one that's been a glue that has held the field together. He's written the history of the field. And I don't think it's too much to say there would not be a field of remedies if it were not for Doug. Now, remedies would still happen. You can't have law without remedies. But it would not be conceptualized as an important domain of intellectual endeavor. And that is due to Doug. In fact, for us to sit up here and say anything about remedies while Doug is here is like living in one long Marshall McLuhan moment, where at any moment he could stand and say, I'm Marshall McLuhan, and you know nothing of my work. So I want to briefly, before getting to some sketchy remarks on my paper, I want to highlight 4 things that are true about the field of remedies because of Doug, 4 particular intellectual contributions, and note that all 4 are highly contingent, because you could imagine none of these being the case if it were not for Doug. So first, remedies is transsubstantive. If you look at remedies case books, if we could do the dating before Doug Laycock and after Doug Laycock, you are likely to see chapters on contract remedies and tort remedies. And the remedies are organized by the substantive law. But the idea that remedies is something that cuts across all the substantive domains, which is absolutely essential to the field, is due to Doug. Second, and let me also say for that, critical within that is a way in which the field of remedies exists distinct from certain ideas about law that would completely collapse rights and remedies. And this can happen from either side. This can be like University of Toronto, Ernie Weinrib, Kantian. The remedies don't do anything except just state what the right is. Or it can happen from the other side with law and econ, where the remedies are setting the incentives, and that's really what's happening. It's not any of this like cheap rights talk. And so to carve out a distinct space where rights and remedies are related and remedies run across the different rights is a signature contribution. So that's one. Number two, what is the goal of remedies? The goal of the remedy is to put the injured person or the person who may be injured into her rightful position. That is now completely taken for granted by nearly everyone, that is the goal of remedies. And that was not considered the goal before Doug. Third, remedies includes restitution. Restitution is properly within the even though it includes substantive grounds for liability, it is a subject of concern that is appropriate within a remedies course. So for almost all students who have been exposed to restitution over the last several decades, it has come from using Doug's remedies casebook. So the fact that restitution is considered relevant for remedies, part of remedies, is what has a key thing that has helped keep it alive. Of course, along with the magisterial restatement by Andrew, which in his contribution for this Festschrift symposium, he notes Doug's pervasive and deep influence on that restatement. And this also shows up in Doug Rindelman and Caprice Roberts' paper. Fourth, equity is not special. The idea that we do not have a separate domain for equity, but we have a unified analysis between legal remedies and equitable remedies, and the question in each case is, what is the best remedy? That is distinctively a contribution of Doug's. He noted it in his talk at lunch. Now, some of you may think on these four that Doug is batting 1,000. Even if you think that Doug is batting 750, that is still well above Ted Williams in his best season. Okay, so the paper, briefly, that I am contributing for this is called Preliminary Injunction Realism. And it tries to be a homage to two key aspects of Doug's work and reflect those in thinking about the preliminary injunction. First, Doug always cares more about what courts do than what courts say. Second, Doug is impatient with doctrinal categories that do not reflect normative judgments and get in the way of getting to those normative judgments. So the effort here is to document what courts are doing on certain key questions about the preliminary injunction, and then also to offer guidance on how to use the four-factor test that is widely used for preliminary injunctions and how to use it in a way that makes more normative sense, including normative judgments within the operation of the litigation process. Like, who has the material to make a certain assertion? The plaintiff doesn't have the material to argue about balance of hardships effectively on the other side. It's got a defense-like quality. Okay, so for this, the empirical part, what courts are doing, for that I have reviewed all the preliminary injunction cases in 2023 from district courts in the Fourth Circuit, the Fifth Circuit, and I'm about halfway through the ones for the Sixth Circuit. There are a bunch of variables, a bunch of different findings I could talk about, but the key finding, the central one, is that the correlation between a court's prediction of likelihood of success on the merits and whether the court will grant or deny the preliminary injunction is over 95%. Now, that's not because the decision correlates with that factor rather than the other factors. It's because it correlates with all the factors because they're not doing independent work, because the merits are doing all the work. And then as soon as the court predicts the merits, the other factors all fall into line. This is not the way it's supposed to work. Happy to talk about that at great length, the problems with that. But that's what's happening. And that is most pronounced if there's a government defendant. So across all these cases from the Fourth Circuit, Fifth Circuit, first half of the cases from the Sixth Circuit, the percentage correlation between whether the court's going to grant or deny the preliminary injunction and the court's prediction of success on the merits in a suit with a government defendant is 100%. And so even though we will talk about a four-factor test, in effect, it is a one-factor test. Now, I don't have to tell you, we are in the great state of Texas, and there are single judge districts in the state of Texas and national injunctions. And if you get to pick your particular judge for that particular judge's intuition about the merits, then it's very easy to get exactly what you want, especially when that intuition about the merits is doing all the work and there's nothing else. This is no way to run a railroad, no way to have a preliminary injunction doctrine. We talk a lot more about what to do about it. Okay, so that's the key finding. Let me just mention for those of you, for the 0.75 other people in this room who care about injunction bonds, the number of—
More like two.
Okay, two, yes, my people. The number of these cases that are giving injunction bonds is very low, and it's under 25% on cases where there is a preliminary injunction granted. And in the cases with government defendants, the number of injunction bonds, I have only found one. A gun store in Kentucky that sued not to have its federal firearms license revoked, and it got a preliminary injunction and it had to put up a bond of $1,000. That's the only one. So anyway, lots more could be spun out about this, but looking at what courts do rather than what courts say is a hallmark of Doug Laycock, and is just one of the innumerable ways in which he has shaped the past, present, and future of the field of remedies.
I think Rick has a question we have just so we know we have 4 minutes. So you came in early. Thank you.
Yeah, my question for you didn't talk about this. I mean, you had one sentence about it now, but it's in your paper, which is you say that rather than the four-factor test being for the granting of preliminary injunctions being four separate factors, as the court suggested in the Winter case, that it should be more of a sliding scale. And some jurisdictions do that, some don't. I've been trying to update that for our casebook, and it's a mess.
It is a mess.
Here's my question. Given what you found, do you think it makes a difference in the circuits that use the sliding scale compared to using the four separate factors in terms of outcomes of cases?
So it's a great question, and I took off my plan had been to do the Seventh Circuit as the fourth one, and I'm still deciding what to do for the Fourth Circuit, fourth different circuit I do. I'm likely to do the Second Circuit just because it is the cleanest and most consistent sliding scale to see if that makes a difference. It's precisely to do that. But I will say, I think the sliding scale is the right way to go, but I want to avoid a fixation on getting the four factors correct as solving the problem. Because I think a lot of what's driving it is loss of a sense of what the preliminary injunction is for, that it's supposed to preserve the court's ultimate options, not to protect anybody from all possible harm. And I think it's that loss of sense of what it's for and its provisionality that is more important than exactly how you construct the test.
Question or no?
No question.
Rick.
All right. First, I want to thank Bobby, who I think has gone now, but this wouldn't have happened without his support, and Steve, who has done more work than he's willing to take credit for, and Sandra, who pulled this whole thing together, and of course to Sam and Chris, who also organized this event. I also want to thank the Review of Litigation, which is based here at the University of Texas, that's going to publish the Remedies papers. So we have a home for them. Last night at the dinner, I said really nice things about Doug as a mentor and as a partner. I'm going to tell a slightly different story, which is today, which is the very first job talk I ever gave was at the University of Texas. And the very first question that was asked at that very first job talk was by Doug Laycock. My paper was a critique of a Posner argument about the duty to rescue. He was making the argument that a duty to rescue someone who's drowning, a stranger, it might be efficient, it might not be efficient, because people who are drowning in the water, they're more likely to be rescued, but people will avoid the beach if they know that they might be called on to rescue. And so I did an empirical survey, like people, it's not a dichotomous thing. Like, what are the chances you think you're going to be a rescuer? And tried to make an economic argument, Calder-Hicks efficiency argument as to why, in fact, it is efficient to require a duty to rescue. And so Doug Laycock's first question to me was, of course Posner's wrong. You're shooting fish in a barrel. Tell us something we don't know. And so it has been my life goal to tell Doug Laycock something he doesn't know, and I've been trying to do that for a very long time with not such great success. He's told me, when I reminded him of the story, he told me he's mellowed, and I think it is true. So I'm going to talk about the book, The Death of the Irreparable Injury Rule, and what's happened since then. And just to be clear, because the nomenclature is very confusing, Sam was talking about the Irreparable Injury Rule as it applies to preliminary injunctions. Doug, in his talk, and what I'll talk about today, is the Irreparable Injury Rule as it applies to permanent injunctions. So it's after a judgment on the merits. Let's say you and I have a property dispute, and I want to cut down a tree I think on my property, you don't want it cut down. The judge decides that it's actually on your property, and so do I still get to cut down the tree and pay you damages, or do you get to get an injunction that stops me from cutting down the tree at final judgment? And the traditional answer to this question was a historic relic of the fact that there were courts of law that gave damages. This is in England, hundreds of years ago, and courts of equity that could give injunctions. And because of a turf war hundreds of years ago in England, that was resolved by saying courts of equity would only act when courts of law would give an inadequate remedy. We get the inadequate remedy at law rule. And Doug thinks that our lives today should not be driven by a historical turf war from 400 years ago, especially because almost all American courts now are both courts of law and courts of equity. And so what's really going on, he says, is that, that's not me beeping, is it? No, I think it's me. Okay. So what he says is really going on is that there are other policy reasons that are driving the outcome, because whenever anybody wants to ask for an injunction, it's because damages are not as good. And so why does it matter? He says in his book, bad doctrine matters because it confuses us, scholars, judges, and practitioners alike. Okay, so Doug's argument that the irreparable injury rule is dead. What did that mean? And again, I'll quote from him. He says, the irreparable injury rule is dead in the practical sense that it almost never affects the results of cases. And so the first thing that I argue in my paper is that the irreparable injury rule is not dead. It is undead like a zombie. That is, it is something that is not alive, but can still do harm. If you watch any horror movies, you know that it can still do considerable harm. And so what do I mean that it's undead? Well, I think everyone in the remedies field agrees that the irreparable injury rule is not really doing the work, but yet there have been no courts that have rejected the irreparable injury rule. And there are no legislatures that have rejected the irreparable injury rule, although Doug and I recently found a Maryland statute going back 150 years that seems to overturn the irreparable injury rule, but Maryland courts don't even follow it. So I looked to see citations to Doug's book, or his article of the same name. There have been 48 cases. They're cited for all kinds of propositions, but no one's seriously questioning overturning the irreparable injury rule. And so the question is, well, what damage does it do? And so I want to talk about what damage it does by talking for a few minutes about a case that the Supreme Court decided, I think it was 2006, called eBay. eBay versus a Merck exchange. This is an IP case. For IP lawyers, they have a kind of a good view of this case. Remedies lawyers do not. So the question was about whether there would be a presumption about whether you can get an injunction or not in a patent case when there's patent infringement. And the Supreme Court said this presumption that the Federal Circuit was doing, bad thing, shouldn't have that presumption. And that, I think, a lot of people thought that was the right choice. Shouldn't have a thumb on the scale favoring or opposing injunctions. But the court said, we're going to apply the traditional four-part test. And as Doug Rendelman said, there was no traditional four-part test. The Supreme Court made it up. And the first two factors, the first one is irreparable injury, and the second one is no adequate remedy at law. And those are the same thing. So I've looked at cases that unlike Doug, who I think had 1,300 cases in the database, I just perused some recent cases over the last few years citing eBay and trying to apply it in the permanent injunction stage, and they're confused. They think one court says we have to determine if there's likelihood of success on the merits, which is a preliminary injunction standard, which shouldn't even apply. Another court misquotes eBay as saying that injunctions are an extraordinary remedy. eBay never said that. And so this goes to the point that Doug made in his book, which is that fuzzy thinking causes bad outcomes. And it turns out that this was an accident. Doug actually went back and traced where did this argument come from in the eBay case. There were no remedies briefs filed. It seemed to be that the district court judge relied on a different district court judge who got the law wrong. And then Justice Thomas, or his clerk, Justice Thomas was the author of the opinion, just to kind of incorporate that in. So now we have a traditional four-part test that has been applied in 5,000 federal courts, and only 38 state courts, thankfully, that hasn't entered there. Only in 5,000 courts since 2006. And it's doing real damage because it's not focused on what actually matters, which are those substantive factors like, is it a burden on the court? Is there a free speech interest here? Like, what are the actual factors? Okay, the last thing I want to say, I only have a few minutes left, is to push back a little bit against Sam's defense of the irreparable injury rule. So Sam has this great metaphor. He says, the irreparable injury rule, getting over it by showing the damage remedy is going to be inadequate, it's not like a high wall. He says it's like when you're driving on the highway and there's a dotted line, and if you're going to change lanes, you need to pay attention and know you're changing lanes. And it's a great metaphor of thinking about this. But then if you probe as to why Sam thinks it's good that we have judges be cognizant of this, it's because he says that what this does is it makes courts cognizant of their vast powers and equity, that they have substantial discretion that they should apply in deciding what they should do or what they shouldn't do in terms of choosing between granting a permanent injunction or granting damages. And so I looked at Sam and, is it Paul Miller? Paul Miller's work on how do judges in equity use their discretion, and I'm concerned. And the concern is when you look at, the way Doug would do this is, well, here's the checklist of things to consider. And this is kind of how our restatement goes. Burden on the court, hardship to the defendant. There's a list of things. And Sam explicitly says, we can't reduce it to a list of things. And it's essentially a judge using virtue and ethics and judgment. And so here's where my problem is. In our polarized society today, judges being completely honest and being completely trying to do the ethical and right thing, these judges are going to be guided by their values. And judges that are appointed or elected by Republicans look different than judges appointed or elected by Democrats. And I'm worried that if we don't cabin discretion by having a list of things that's at least the focus that judges should apply, that we're going to get more value added judging. And I make an example, I make an analogy in the paper. My real field is not remedies, it's election law. In election law, there's something called the single subject rule that applies to initiatives. you can't have an initiative that has more than one subject. Well, what does that mean? Some courts have a lax view of what subject is, and they let everything go to the voters. Some have a strict view. So I did an empirical study with another scholar, and in those places where they have a strict view, we find lots of ideological judging. And in those that have a lax view where most things get through, you don't see that. And so my concern is that the more we tell judges that they should use their unbridled discretion, that they should use their judgment, that they should use their ethics, the more we're going to get judge shopping, where they're going to the, go to the Ninth Circuit if Trump is president, and go to the Fifth Circuit if Biden's president, and we're just going to see more polarized judging. I'd rather see a list of factors. That is more constraining because at least we can then critique the judges and say, you didn't follow all of these factors. So I did some Googling because I'm not a horror fan watcher. How do you kill an undead zombie? And the answer is, again, you can correct me because I don't watch these movies, you have to attack the brain. And so I feel like Doug Laycock's work has been trying to attack the brain of the judges who are still stuck on the distinction between law and equity, and not doing what he has said in his book and what we now say in the restatement: give the best remedy to the wronged plaintiff, all things considered. Thanks.
Sam or Emily, question for Rick?
No.
Okay, Emily.
Well, do we have others?
No, then we're going to go
Others at
questions
the
after.
end.
Okay, questions, that's right, we decided that. Okay, so I'm a little at a loss for exactly what to say here, because Doug and then Sam, well, everybody has so far taken up most of what I was going to try to say, so I have to come up with some slightly new ways to put that. I do have a slightly different angle. Brian Leiter caught my attention by quoting some statements from Doug's book on the irreparable injury, and also the later argument. Well, they tie into the later arguments he made under in the paper Triumph of Equity. He said there in particular that historical equity plays at least as great a role in law across remedies, as historically that equity plays at least as great a role as law in both all of remedies, substance, and procedure, I think is, if I had to summarize it in one sentence. Now, Brian Leiter got hold of that, and he wrote an article in which he said, well, like the realists, he claimed Laycock as a legal realist through and through, saying that he finds a disjunction between law in the books and law in action. He invokes as an explanation for that the decision-maker's intuitive sense of justice, so far probably fair. Then he said, like Oliphant before him, Laycock seeks in turn to reformulate and restate the rules governing injunctions to reflect the actual pattern of decisions following this intuitive sense of justice. That's where I think maybe Leiter went a little too far, because I don't read things as read Laycock's actual writings as going quite that far. I think that his approach, Laycock's approach, not Leiter's approach, is actually not so simple as Brian's legal realism. And I don't think that he is, in fact, a rabid legal realist, maybe with a touch of legal realism. But Leiter notwithstanding, what I see Doug's view of law as being closer to is something that the late, great Fred Schauer wrote about, which he called presumptive formalism. And he proposed that rules of law do have meaning, and they have significant benefits coming just from that fact about them, that they are meaningful rules. They provide predictability, guidance, even-handedness, a variety of things. But in all the cases, that value is rebuttable. So there's a plausible, although kind of hard to describe, middle ground between the value of rules and the fact that you should support rules, but you should not support them in every case and always. That, to me, is a very sensible position, and it's really how I read Doug. I don't see the essence of realism in what Doug is saying. The essence of realism is, I'm going from quote to quote here, that idea of an intuitive sense of justice in disregard of the rules, law and action not matching law in the books. I don't see Doug as going that far. I see him as taking a different approach to what you're trying to do and what restraints you want to keep as you move away from an automatic prevalence of rules over equity, that you still may want to use, understand first, then use a number of the characteristics of rules that do produce some good outcomes. That's a little short, but as I say, I was not expecting him to go through the whole story for me. I had the whole story all written out in a way that I could present, but no, he covered almost all the ground in almost exactly the way I would have put it. But I like his position very much. I think I've never had a problem with rules. I think rules are, most of my own work is in private law areas, and there are not a lot of reasons why private actors in law need the guidance of rules, need the kind of reliability of rules, need to think of them as something that will pretty much stay where they are as they proceed through the transaction that they worked out on the basis of these rules. And I don't see Doug as going too far away from that basic thought. I see him only as saying, we don't want to carry, to carry this to a fixation on rules and a precise application of rules, but not doing away with the guidance, rather striking this balance in which you you say that the rules are serving some purposes, but they also shouldn't be taken as foundational, or maybe they're that there is a middle ground in which there is some value in some solidity to the rules, especially in the private law area, but we don't want to give that some sort of absolute value in what we now think of as law, which I think is a sensible description of the way American law, I've done a little historical discussion of American law, where it began at the beginning of the 20th century, where it ended up, and especially in comparison with English law and other Commonwealth nations' law, definitely the realists had a major impact. And, but I don't think it's as extreme as Leiter would like it to be. I kind of like it to rest where I think Doug wants it to be. Those rules are not ridiculous. They do still have a function in the area of private law. But they also, we're just long past what is still not too extraordinary to see in English law. We're past the point where the words of those rules are set in steel, thanks in, maybe a little bit to Brian and his realists, but largely to Doug himself, I think, has done some work on that. But, so that's a little incoherent, but as I say, I had to redesign it in response to everybody already stealing my show.
So Sam or Rick, do you have questions about Emily's paper?
I just want to make a quick observation, which is that I don't know anything about law and religion, and I don't read in the field, but having listened to the presentations this morning, I'm struck by the parallels in terms of, with listening to Emily's paper, with the reasonableness and the lack of extremism and the importance of rules and text, but not being dogmatic about it. And I mean, maybe, I guess it was Mark Gergen who started with the word pragmatism. That really seems to be the theory of Doug overall.
I agree, and also that it spans the private law area that I'm most worried about, and religion as well. If you
Can I-
want to adjust with the movement of U.S. law during the 20th century, it's pretty much just what's called for, yeah.
So if I can add an agreement, or maybe consistent with the first two panels this morning, if I can add an amen to the the two panelists to my left. Tom Berg's paper talked about how Doug had such an interest in and commitment to thinking seriously through competing interests, not just immediately picking one interest or the other and following it come what may. And that is characteristic in the religious liberty work, and it's also characteristic in the remedies work. So if the death of the irreparable injury rule does this in chapter after chapter, it's critical to how Doug thinks about the injunction. It's critical to how the restatement, third of torts, remedies, is going to do this. So it's a serious, close attention to interests. And I don't think it's an accident that Doug came to remedies through the class on injunctions, because this is how injunctions work. Injunctions always have to take into consideration the interests on both sides. Now, that happens in various ways in tests, but even if you don't have tests, before anybody invented a four-factor test for anything, you're still taking into account interests on both sides. And that's just always, that's part of the way it works. And then that's true for Doug's work on that every panel today talks about.
So we have time. I just realize you have to wait for the mic, okay.
So I think this is, Rick, I want to start, I think it may be a question for everyone, but I want to enter into it with eBay. And eBay it's a glaring and significant embarrassment. But I think it feels that it might be too much to attribute that causally to the irreparable injury rule. The fact that they couldn't even articulate the most basic version of that rule tells me that the fuzzy thinking was pre-existing, right? They couldn't, it was just horrible, terrible research. So it's not the rule that was doing it. There's just something there, and you know, whether it was Justice Thomas who's ultimately responsible for his opinions or the clerk, how does something leave the Supreme Court that's just not even the most basic statement? So there are two things that I think can happen, and this is the invitation. In the face of doctrine that's problematic or that's contested, you have defenders who can justify it, and you have those who might just try to destroy it. As an analogy, in the doctrine of bargain for consideration, you have someone like Grant Gilmore, who writes The Death of Contract, which is this. And I'm also curious whether how that article connected with Doug's title. And then on the other side, you have people who try to justify doctrines. So you have Lon Fuller, who himself is a great remedies person. His first article, early articles with his student, Will Perdue. And Fuller justifies it by saying, in addition to substantive claims, oh, you know, actually this consideration, it's like a form. The doctrine, it's a form, and it has substantive values, but it also has functional values. It has a channeling function. So you know, and that channeling function sort of sounds like Sam's dotted lines. You know which way you're going. Fuller said also forms and consideration has a cautionary function. So before you enter into these contracts, you can't get out of them. And that kind of sounds like Doug Rendelman's and Dan Dobbs and Caprice's The Awesome Power of Equity. If you're going to use it, you ought to do so in a cautionary way. And then there's the evidentiary function, that you actually have to spell out your reasons for why you're doing this. That sounds very much like Doug's claim that you have to give the reasons. So is there a justification, kind of Lon Fuller, the rule that the way consideration works for contractors, the irreparable injury rule actually has a positive account for judges who are making these decisions that are so weighty. So that's a very long and roundabout question, but I was just wondering, Doug wants to destroy it. Sam is giving some account. Is there a positive account?
Well, first thing I'd say, it's a very rich set of questions. I'm not going to address all of them, but the remedies, especially before Doug came on the scene and kind of systematized our thinking about it, were always an afterthought. So as we're working on the restatement third torts remedies, I like putting the colon there to remind people, tort remedies, we're looking at the second restatement because we have to say, oh, we're updating this, we're changing that. And it was very thin. Now, I think it's because Prosser was at the end of his career and he didn't have a lot of time. But like, when I taught contracts, remedies were like the last day. When I teach torts, remedies is the last 2 days. Like, it's always the afterthought. It's never the centerpiece. And I think that, as Doug points out, there was no remedies brief, amicus brief, filed in that case. I mean, I think because it was thought of as an IP case, and we didn't know they were going to do all these kind of changes generally to thinking about permanent injunctions. But if you look at the reaction to eBay, lots of IP lawyers think this was good. This was actually a defense. Not that they articulated a sensible four-part test, but that they got rid of these presumptions that made it too easy to get injunctions, that was causing these hang-ups in patent trolls and all these other things. But those are kind of two separate questions. One is, did the court get the result right to throw out what the Federal Circuit was doing and to get rid of presumptions and create a more even field for damages versus injunctions? The other is, did they come up with something better? And what they've come up with is a morass. And so I don't know, I can't think of a single remedy scholar who defends the four-part test. I mean, Sam defends the idea that I think the result was right in eBay, but I don't think you defend that particular four-part test.
I don't defend the four-part test. There have been several scholarly attempts, including one by David Shapiro, to distinguish between irreparable injury and no adequate remedy at law in the permanent injunction context, though I think ultimately they don't really work. So I think they are the same factor, but it's not risible because people had done it, but it's just not good law. So I don't really defend having, and I once had an RA look through tons of permanent injunction cases to see if any came out one way on the irreparable injury factor and a different way on the no adequate remedy at law factor, and it was a null set.
I would just add one possibility to this is that, at least it's something I've noticed, that over the particularly second half of the 20th century, despite that some of us still teach remedies and pursue scholarship in remedies, in the law schools, and it's the law clerks here are law students recent law students from good schools. Remedies is disappeared from so many schools' curricula, and there just is no systematic. I mean, there's fortunately Doug's book, and maybe mine and Sam's, but there's not. They're not learning. They've taken legal realism in its extreme sense seriously, saying that it's all just intuition, and especially when you get to the remedies part. And it isn't all just intuition. It has to be. I mean, it shouldn't be all rules. That's why I like Fred's approach. But it's got to be something more than sheer intuition. It's got to be in some way reasoned and and applied to cases in a way that's informed with some learning. So I see a few more remedies courses around now, but it's still slow. They've started back up at Harvard, but it's going slowly.
So I'm going to sort of do a follow-up. If we put eBay to one side as an abomination, so just put that over here, right?
So to speak.
Yeah. And there's sort of two things that could be happening. So one of the things that Doug said in his comments at lunch is if courts aren't applying the irreparable injury rule, what are they doing? So one could be that we have law students and maybe some judges, they didn't take Doug's remedies class, they don't know what they're doing. The other could be, and I forget who made the comment about the Amarillo district in the state of Texas, that maybe those judges know exactly what they're doing and that they're getting to a result that they want to get to. And so I'm sort of torn when I teach both Civ Pro and Remedies, when my students are basically saying, you know, judges just do whatever they want to with injunctions, particularly the nationwide injunctions or injunctions in ballot initiatives or in abortion cases. So I guess, are we sure it's just incompetence as opposed to quite competent?
So I don't think it's just incompetence, and I think both parts of that story are important. I do think there's value and limits in legal doctrine. That is, I think, the key point here. So this is where so Doug mentioned in describing himself as a realist who cares about legal doctrine, that doctrine guides and doctrine can help shine a light on and focus you on the right things you need to take into account, the right facts to care about. But it can't make you get there. And so, I take Rick's point about judicial polarization, and I think it's good to have legal doctrines that reduce the interpersonal variation between judges, that play that down. I also just don't think you can do remedies doctrines, particularly equitable remedies doctrines, that get that to zero, and I think the cost of doing that is too high. So I think what you want is guidance, but it does require a judge who wants to be guided. And I don't think there's any way to completely escape from that.
No, but you can make the guidance a little bit stronger than it lately has become. I mean, you don't throw it out the window. You need that's what we all do, right? So, sorry, there's some questions there. Caprice.
No, Caprice.
There's a tension between your papers, maybe an irony. Because Sam, you say in the area where they are told to consider irreparable injury on both sides, they don't. Right? They just decide based on the merits. And you say, Rick, there is this irreparable injury rule that when we get to the final merit stage that seems to, you are worried is doing some work. It's odd that if both of those things were true. I
don't think it's true that irreparable injury is doing work. I think they go through the language of it, but something else is going on.
Well, but I actually think, and I was looking in the time permitted at this Sam's Vanderbilt paper, which I hadn't seen. I actually think the preliminary injunction cases are different. Meaning that what I would there's something about self-selection when somebody's seeking a preliminary injunction that makes the judge's prediction on the outcomes much more determinative because of the nature of that type of case. And you're looking at a broader universe of cases, on the merits cases.
Yeah, not looking at the preliminary injunction. I think that the irreparable injury rule is doing work in the preliminary injunction context.
Well, but Sam was saying it doesn't.
So
and you would think it would do some work there, and I think there's something about the universe of preliminary injunction cases that you may say a word about.
Okay, so I think Rick is right, and Doug in the death of the irreparable injury rule is right. That regardless about what you think about the irreparable injury rule at the permanent injunction stage, no adequate remedy at law. It is a different doctrine, and it does real work at the preliminary injunction stage. And it's about whether injury is going to happen that the court cannot remedy after trial. But, right, so it does work in the sense of it is an independent doctrinal variable. It doesn't do work in the sense that the courts have, federal courts have now gotten themselves to the position where if they find a prediction of success on the merits, then they collapse that factor in. So it should be doing work. As a matter of black letter law, it does work. As a matter of actual on the ground, what's happening, it doesn't. And here I think it's important to go back to Mechele's point, because what is, I think, leading a lot of the charge on the collapse of the preliminary injunction into the merits is Fifth Circuit, Sixth Circuit, precisely places where the definition of what's counting as irreparable injury is now expanded. That those two circuits have now created a circuit split, unacknowledged so far by the Supreme Court, about whether routine compliance costs with a new government rule count as irreparable injury. They say, yes, that's irreparable injury, which means anybody who ever wants to challenge any government rule always has irreparable injury, even if you have to like reprint your employee manual, then that's irreparable injury. And it's not an accident that that is precisely where the challenges are being brought to Biden administration policies. So I think the point you made and the point Rick made and the point Mechele made are all right on this.
Professor Roberts.
Hi. I really enjoyed all of your papers and hearing your remarks today. And it makes me think a lot about where Emily ended about the courses sort of disappearing, scholarly articles to some extent. They're not disappearing, but they're not getting as much attention as they deserve, and that's in part because of the way the perception outside the field of what the field is. But that makes me think about, well, there's all these great things we're doing, including the legacy that Doug Laycock is bringing, and then I was thinking about the four factors as Sam put it, right? So as you listed out those four, I couldn't help but thinking almost all of the four might be fundamentally flawed or dying themselves. So I'll start with the fourth, which is the law and equity one, right? Sam, it's ironic that you're bringing up that one about equity, not being separate, but you write about equity should be separate, so there's a little bit of disjoint there, but I think that there's a way to reconcile it because you both would agree that equity is really important. Then I thought about the one about restitution. It's so important that Doug Laycock is responsible for making sure that was a part of the Remedies course, which I love teaching it in there. But if I'm to ask honestly, should it be there? No, because we're teaching substantive law in a way that should be its own course, which we could do if law schools wanted to have that and do that. So if we had to do it over again now, would we choose differently? And is there any way to talk law schools into doing that as well? And then on the sort of the one about the rightful position, we had a little bit of a conversation about that last night, so I'll leave that to the side as to whether that is still accurate, but I think many people do follow that, but maybe it's not completely descriptive of what's going on. And then the first one, and this is what I wanted to ask everyone, the remedies as transsubstantive. And I'm always talking about that. I always think about remedies that way. I think it's so important so that you can cut across and come up with principles that matter, and so that it is a field, right? That's near and dear to what we do. So I haven't told many people this, but when I took over the Remedies treatise, I had many, many conversations with Dan Dobbs, asked him all sorts of things, because mainly he was trying to pitch me and sell me on why this was a great thing to do for the field, and yet he was not going to be able to help with it. So I had very little time with him. I had very little time with him to say, let me glean everything I can before I start this project. And the very last question I asked him, because I wanted to sort of let him be done with the project, the last question I asked him, if you had it to do over again, would you do anything differently? His answer shocked me. He said, yes, everything. I was like, tell me more. He said he would not have it be transsubstantive. I haven't had the chance to follow up with him now since I've done anyone who's looked at the treatise. I did not take that advice. And he said it would be dangerous to take the advice because practitioners and judges and so many people rely upon the treatise. They wouldn't like the change. But that's not why I didn't do it. I didn't do it because I'm a believer in the transsubstantive nature of remedies. So I want to know what some of you, at least Sam and Doug and others, if you have thoughts on, is that important, or are we staying overly entrenched in that? If we went away from transsubstantive nature, would it then get back into some of those 1L doctrinal courses where it's disappeared as well? So most of my colleagues are not teaching anything remedies related to their doctrine, related to sort of towards contracts. They're not reaching it, they're not hitting it. So I want to know what you thought of that.
One thing I would just say, just as a matter of law school curriculum, is that, you know, when I first started teaching, I think contracts and torts were 5 units where I was teaching. Now they're 4 if you're lucky, right? And so something's got to go. It's in the last chapter of the book. It's like there's something called remedies. You might get something for your client. You'll have to hear about it another time. So I think part of it, you know, like you're saying people could take a standalone restitution course, and I know Andrew and a few people teach that or taught that, but it's like we now have so many more people taking clinics. There's so many more offerings. It would be great to get it back in the first year curriculum. What I tell professors is teach remedies because you get the highest student evaluations in that course because the students' expectations are so low. They have no understanding of that they're going to get a review of torts and contracts and property and public law and private law and con law all together, and they're going to, I tell them, this is the class, I think this comes from Doug's teacher's manual, this is the class your future clients want you to take. I get more questions from former students and more thanks from former students who took the remedies course than any of the other courses I teach, because that's what they're hitting. And so, like, we have to do a better sales job. We're selling a toolbox that they really need.
All right, so I have a bit of a slightly different perspective on eBay as someone who feels doubly responsible for the result, because I as an associate, wrote a brief in a district court case which got the district court to deny an injunction long before eBay, and then that was summarily overruled by the Federal Circuit in an opinion which created the general rule language that the Supreme Court then found so upsetting there. And then I was part of the litigation team for Merck Exchange and eBay at the Supreme Court. And one question I have with regard to the irreparable injury rule is, I mean, this is coming partly from the patent perspective. When you're saying a doctrine isn't doing real work, I just wonder, I think maybe you have to have more carefully define that, because I would say in the wake of eBay, the doctrine is doing real work. That if you're a patent assertion entity, a so-called non-practicing entity whose business model is to monetize patent rights, license them, or enforce them in court to others, you basically don't get an injunction after eBay. And that's going to be, the courts are just going to decide your ability to get a reasonable royalty remedy, although the courts have shown and continue to show, the Federal Circuit just went en banc on how to calculate reasonable royalty. They have no idea how to do it in any reasonable way. So there's no real, in these cases, not much substantive analysis beyond you're a patent assertion entity, so legal remedies are adequate for you. You know, we don't have to have any showing of undue hardship, say, by the other side, et cetera. So there's one question about what constitutes, you know, real work, and whether there's a normative judgment people are making is what's legitimate work by a doctrine here. And in terms of the IP community, I would say they're divided on this. If you talk to IP lawyers who primarily work for the tech companies that were pushing the eBay rule first legislatively and then before the Supreme Court, of course they're going to be happy. Well, some of them are going to be happy with the rule. The tech community is getting a little more divided on this, but many are opposed to it, and there's a big push, both legislatively and now before the Federal Circuit, to overturn or at least severely limit eBay in patent cases. So I do think in terms of the origins of eBay, you know, it can't be blamed totally on the patent community, I think there was a larger concern. The SG's office came in favor of 4 factors there, not quite the same formulation Justice Thomas had. I think that, personally, from my perspective, that reflects a longstanding concern that activist courts have been too eager to issue injunctions in a variety of cases, like environmental cases, prison litigation reform, busing, et cetera. And so there do seem to be somewhat larger currents at work in terms of what's going on there.
So as you're responding, it's 1:44. We end at 1:45. I'm an associate dean, former associate dean, so if we could keep it short.
I'll just say there's a big difference between the part of eBay that says we're not going to have a thumb on the scale favoring injunctions, which that's definitely doing work, versus the way the 4-factor test has been articulated, and especially as it's applied outside the patent context, where you watch the courts go through the somersaults where they're trying to say 2 different things when they're going through the first 2 factors, and they just end up repeating themselves. And it really does not seem to be driving anything.
I think there's also a key move that Doug makes in the death of the irreparable injury rule to say this doctrine, irreparable injury, is not doing the work. Sub-doctrines that have reasons are doing the work. And you can look at that and say, this doctrine is doing the work for these reasons, or you can look at it and say, these doctrines are doing the work. And so something is doing work, and there's a disagreement about the relative abstraction about legal form.
That's great.
If you could all join me in thanking our panelists.